5 years ago, California changed the rules on property taxes in a way that unlocked a real financial opportunity for all of you long-term homeowners. Now, most of the people it was designed to help still don't even know it exists. So today I want to tell you about a conversation I have all the time. I'll be speaking with a homeowner and they've been in their house since the late 80s or 90s. The kids are grown, the place is too big. Maybe the stairs are starting to be an issue. Maybe they want to be closer to the grandkids somewhere else in the state. And they've already made up their minds before we ever spoke. They say, we can't sell. If we sell, we lose our tax base. Our new property taxes will be 5 times what we're paying now. So we're stuck. And almost every time I have to tell them the same thing. You're not stuck, you're just working off rules that changed 5 years ago. Proposition 19 went into effect back in 2021. And here's what gets me. 5 years in, a surprising number of long-term homeowners in Santa Clara County still have no idea what it actually says or what it means for them. The law was specifically designed to help people in this exact situation. And it's just sitting there, often unclaimed. And that's what we're going to fix today. Now, a quick note before we get into it, nothing in this video is tax or legal advice. Prop 19 has specific eligibility rules, timing requirements, county filing procedures, etc. What I'm giving you today is the framework, so you know the right questions to ask your CPA and your estate planning attorney before you make any decisions. So please do that. So let's talk about what's actually happening out there. So I work with a couple in Cambrian, bought in 1994 for $310,000. The house is now worth around $2 million today. Now, their property tax bill is based on an assessed value of roughly $390,000. They pay about $4,800 a year. Now, they'd love to downsize to a single-story home in Roseville. Maybe that home would be $900,000. And they think the math doesn't work because they'll blow up their tax base the moment they sell. Now, second scenario, I've also talked with a couple who did a Prop 60 transfer back in 2007, the old program. When they downsized the first time, now they want to move again closer to family in Morgan Hill. And under the old rules, they were done. One transfer, permanently done. And that was it. Here's what Proposition 19 changed for both of these families. The first couple, the new rules are more flexible and more powerful than anything that existed before. The second couple, that door that looked permanently closed, it's open again. But here's the part that actually costs people real money. And this is what I need you to hear before anything else. Prop 19 isn't automatic. There are deadlines and there are forms to be filled out and there are timing windows tied to the close of escrow on your sale. And if you miss them, and you lose that benefit permanently. So I've talked to enough escrow officers and tax attorneys in the county to know this happens more than most people realize. A seller completes a move, Prop 19 already in effect, nobody on the transaction mentions the filing deadline, and the tax-based transfer is gone. Now, property taxes on the new home come in at $14,000 a year instead of the $4,200 a year that a timely filing would have locked in. And that's nearly a $10,000 mistake every year for the rest of the time they own that home. Now, it's not a rare edge case. It happens because nobody in the transaction explicitly owns the responsibility, and the seller doesn't know to ask. So let's make sure you know. So I'm going to walk you through 4 things, and I'll tell you right now, number 3 is the one that affects your kids and your estate planning. If you have a home you intend to leave to your children someday, that section might be the most important thing in this entire video for you. So number 1, property tax portability. Here's the core benefit for sellers over 55. You can transfer your existing assessed property tax value to a replacement home anywhere in California, not just within Santa Clara County like the old days. Not just within a handful of participating counties like the old Prop 60 rules. Anywhere in the state, which is nice, right? You sell your primary residence, you buy a replacement primary residence within 2 years. And here's something most people don't know. That 2-year window runs before or after the sale. You can actually buy first and sell second if that timing works out for you better that way. Now, if the new home costs the same or less than what you sold for, your assessed value transfers completely, dollar for dollar. Now, if the replacement home costs more, you carry your old base and only pay the full rate on the difference above your sale price. You're not starting over, you're just paying the premium on whatever you spent above what you sold for. So let me make that clear. Your home in Cambrian sells for $1.5 million. The assessed value is $400,000. You buy a replacement property in Scotts Valley or Roseville or Sonoma County, wherever in California, and that property costs $1.2 million. That's less than your sale price, so your $400,000 assessed value transfers over to the new home. Property taxes on the new home are calculated on $400,000, not that $1.2 million new purchase price. That's the difference between $5,000 a year and $15,000 a year, every single year for as long as you own that property. Now, a lot of sellers who want to leave the Bay Area entirely have been sitting tight because they assumed moving out of Santa Clara County meant losing their tax advantage. Now, that is no longer true with Prop 19. You sell in Willow Glen, buy in San Diego, transfer your tax base, subject to the same rules I just walked you through. Now, that one fact alone changes the retirement calculation for a lot of long-term homeowners in this market. Here's the eligibility basics. You must be 55 years or older at the time of the sale. Now, severely disabled homeowners qualify regardless of age, as do victims of wildfire or natural disasters. But that's not too common here in Santa Clara County. Now, the replacement home must be your primary residence within 1 year of purchase. One clarification before we move on. Prop 19 portability doesn't reduce your capital gains tax. That's a completely separate calculation. And I have a full video on the Section 121 exclusion and how it applies to long-term homeowners here in San Jose. I'll put the link in the description. Now, number 2, the filing requirement, and this is exactly where people get hurt. The form is called the BOE 19-B. It's available on the California Board of Equalization website. You file with the county assessor in the county where your replacement property is located, not the county you're leaving, the county you're moving to. Now, the general deadline is within 3 years of the purchase date of the replacement property. Your 2-year window to find a replacement property starts on the close of escrow on your sale. Not the listing date, not when you accepted an offer, the actual close of escrow date. That's your starting deadline. And I'll say this plainly, don't assume your title company or your escrow officer will file this for you. Some might mention it, many won't. Now, this is something I walk through with every over 55 seller I work with before we ever put the house on the market, because once escrow closes, there's no going back and correcting it. It's your responsibility, so you need to own it. Now, number 3, parent-child transfers. And this is where I need you to really pay attention, because this is also the part that most real estate agents don't fully understand either. This is where Proposition 19 gave with one hand and then took with the other. And it's the section that estate planning attorneys and CPAs care about most when they're advising clients who own California real estate. Now, before Prop 19, parent-child transfers were broadly protected. When a parent passed a home to a child, the property transferred without a property tax reassessment, regardless of what the child did with it. They kept it as their own home, they rented it out, whatever. The low assessed value passed with the property. Now, Prop 19 significantly narrowed that protection. So here's what the current rule says. If a parent transfers a primary residence to a child, the child can only retain the parent's assessed value if the child uses the home as their own primary residence. And even then, there's a cap. If the fair market value of the home exceeds the parent's assessed value by more than $1 million, the amount above that threshold gets added back into the assessed value. So let me show you what that means with real numbers. A parent bought a home in Almaden in 1988, current assessed value $250,000. The current market value, $1.9 million. Now the gap between those two numbers is $1.65 million. The child inherits the home, moves in, claims the exclusion. The first $1 million of that gap is protected. No reassessment on that portion, but the remaining $650,000 above the cap gets added to the $250,000 base. Now, the child's new assessed value is $900,000, not $250,000. It's still a real benefit, but not the full transfer the parent may have assumed the family was getting. Now, here's the version that catches families completely off guard. If the child does not move in, if they decide to rent the property, hold it as a second home, or sell it later, the full reassessment applies. The county reassesses at current market value. Now, on a $1.9 million home, property taxes go from roughly $3,100 a year to roughly $24,000 a year on a property the family thought they were keeping as a long-term rental asset. Estate planning attorneys I work with in this county tell me this scenario, families inheriting properties under Prop 19 without understanding the new rules, is one of the most common planning failures they're seeing right now. It's not that people are making bad decisions, it's that they're making decisions based on rules that no longer exist. Now, if you have a home you intend to leave to your children and your kids are not likely to use it as their primary residence, you need to be having this conversation with your estate planning attorney now. Not when you're ready to list, not when you're doing your taxes, now. The old assumption that your kids would inherit the house and run it as a rental at your favorable tax rate is no longer accurate. Now, number 4, the timing and filing sequence. This is the administrative part, but stay with me because this is exactly where the money gets left on the table. So here's what it looked like. You sell your primary residence and the clock starts. You purchase your replacement primary residence within 2 years of the close of escrow. Remember, you can buy first and sell second if you find the right place and if that's what works for you. Within 1 year of purchase, you must be using the replacement property as your primary residence. Then you file that BOE 19B form with the county assessor where the new property is located. Now, if you're the adult child receiving a property through a parent transfer, the equivalent form is the BOE 19P. Same basic principle, file with the county assessor, establish the property as your primary residence to qualify for that exclusion. And one more time, because it matters, filing is your responsibility. Ask about it explicitly before your transaction closes. Make sure someone in your corner, your spouse, your CPA, your attorney, is tracking that deadline. Now, here's the objection I hear most often when I walk through all of this. Kip, my CPA handles all this. I don't need to worry about it. And I want to answer that honestly. Your CPA is excellent for the income tax side. Capital gains calculation, Section 121 exclusion, tax year timing. That is absolutely their domain, and you should be leaning on them for that. But most CPAs aren't tracking your property tax administration deadlines. They're not watching your escrow timeline and calculating your 2-year portability window. They're not filing county assessor forms on your behalf. Each professional covers their own zone. What creates problems is the assumption that someone else is covering the zone for you when it's ultimately your responsibility. My honest recommendation, bring your CPA, your estate planning attorney, and your real estate agent into the same conversation before you list. The decisions made in the planning phase are almost always cheaper than the corrections attempted after escrow closes, and that's if they're possible at all. Now, Proposition 19 rewards the people who actually understand it. There's no penalty for not knowing, you just don't get the benefit. And in a county where a property tax base can represent $10,000 to $15,000 a year in savings, not getting the benefit is an expensive thing to miss out on. One last time, remember, nothing in this video is tax or legal advice. Please work with a licensed CPA and an estate planning attorney before making any decisions based on what you've heard here. If this helped clarify something you've been sitting on, subscribe. I put out videos like this regularly, and if you have a specific question about how Prop 19 applies to your situation, drop it in the comments or just give me a call. There's no pitch, no pressure, just a real conversation. Thanks for watching, and I'll see you in the next video.